Welcome to the Virtual Center for the Study of the Constitution of the United States, an ongoing conversation about American origins. The Executive Director of the Virtual Center is Dr. Bill O'Brien. He's also your host for this dialogue. And here he is now, Dr. Bill O'Brien.
Thanks, Bob Kincaid, and welcome everyone to today's edition of the Virtual Center for the Study of the U.S. Constitution. I am Bill O'Brien, and it is a pleasure to be with you today on this beautiful Tuesday here in the mountains of Appalachia, here in southern West Virginia. Welcome to the program, and if you are a first-time listener, we really do welcome you. I'll be giving you a phone number. If you choose to call and offer your thoughts, your comments, your ideas, your suggestions, or whatever during the course of the program, we would love to hear from you. And if you are a regular listener, I do not want to be remiss in welcoming you each day as well. Thank you so very, very much for giving us a portion of your very valuable time. And as I have said numerous times, and I try to remember to say as often as I can, I do, in fact, not take for granted the fact that you are giving time to listen to this program. I feel that I have an obligation to make your commitment of time, your very valuable time, worthwhile. And I hope that the programs meet your expectations to the point that at the end, even if you didn't agree with or particularly like everything that was covered in the program, that you can at least say that it was a valuable use of your time. That's a commitment that I have, and I frequently mention as well that I usually get a little bit nervous before each program because I make this little deal with myself. I kind of, just silently say to myself that I hope I can do the material justice, because it's rare that I come to a program like this, or when I was teaching every year, or to a class. It's very rare that I don't really believe that the information and the material that I'm planning to cover is information and insight that I believe is valuable to know. I believe that people will be better off for knowing it than they will for not knowing it. I believe that. And that kind of puts a burden of responsibility on me to make that case. I mean, my job is not just to convey information, but my job is to basically be able to prove that the transmission of this information and the comments that I might have about it are worth knowing. Whether in fact people agree with them or disagree with them, that's not really the point. But if they expand understanding and knowledge, they expand perspective, and they contribute to one's overall understanding of the world we live in and the people who live in that world with us, then it seems to me that it's been a valuable use of my time, and I have to trust, a valuable use of yours. If you would like to comment during the program, or ask a question, make a comment, offer a criticism, make a suggestion, whatever, you need to know that the purpose of this is for you, not for me. I could do this in front of a mirror. But the fact of the matter is, if it's not valuable to you, then I need to know that. And so I value, I welcome, I cherish your input, your comments. So if you are so inclined, please feel free to call. Don't feel like you'd be interrupting anything, or don't try to wait for the appropriate moment or whatever. I've mentioned a couple of times that a couple of emailers have suggested that the top of the second hour, because usually we take a 5-minute break at the top of the first hour, and that's a good time to call. In fact, I even thought about organizing the program in such a way that the first hour would be information and analysis and those kinds of things, and the second portion of the program would be commentary and questions and discussion and dialogue and the rest of it. The problem with that's a great plan. The problem is that I have to know that there'll be people on the other end, and there'll be people responding. And so until we get to the point where I can be pretty sure that happens, I'm a little bit reluctant to go in that direction. We could have a pretty quiet second hour, I guess is what I'm saying. Anyway, the phone number, area code 304-658-3333. That's 304-658-3333. That will get you into the Head On Radio Network studios, and we'll get you on the air in a matter of seconds. If you would like to email me directly about the program, if you have a comment or a suggestion or whatever, I would love to hear from you as well. And I will do everything I can to respond to your emails. If you take the time to write one, I darn well owe you the time to respond to it. My email address is WAObrien, OBRIEN, 906 @gmail.com. That's WAObrien, OBRIEN, 906 @gmail.com. I wanted to begin today's program by finishing up on a document, what I think is a very valuable document. In fact, I'm going to go out on a limb here today and make a couple of comments about this document that, but in rereading it, I've read the thing. I had read the thing, several times over the years, but in the last couple of days, I've read it 3 or 4 additional times. And the more I read it, the more I appreciate it for what it is. And so I want to share that with you. But if you remember yesterday, we looked at the Supreme Court decision in the case of Lochner versus New York in the year 1905. And in that decision, the Supreme Court, in a 5-4 decision, the decision was written by Justice Peckham, Peckham. It was a 5-4 decision, so it was not unanimous. The court struck down the constitutionality of the state of New York law regulating the hours that people working in bakeries could work. The legislation for the protection of the health and safety of people working in bakeries. The legislation required that nobody working in a bakery in the state of New York could work more than 10 hours a day or 60 hours per week. And the baking industry took that to the Supreme Court. And in a 5-4 decision, the court struck down the constitutionality of that law, arguing that the law violated the Due Process Clause of the 14th Amendment because it effectively interfered with the freedom of both the worker and the employer to make a contract on the hours and conditions of one's labor. Basically, the court's position was that a part of being free in a society like this is the ability to purchase labor, is the freedom to purchase labor and the freedom to sell it. And the court ruled that that process, that freedom, which is guaranteed under the 14th Amendment, no person can be deprived of life, liberty, or property without due process of law. That's what the 14th Amendment said. That this was a state interference with the freedom of people to contract. In the case of the worker, to contract for their own labor, and in the case of the employer, to contract to hire that labor. And we read the decision, a good portion of the decision yesterday, if you'll recall. And that was the court's position. The court also ruled in justifying its position that the argument that working in a bakery was so dangerous as to warrant the state's interference under the exercise of its police power. States, by definition, have a responsibility to intervene or to regulate circumstances which affect the life, safety, happiness, morals, education, etc. of their citizens under the police power. And so the right to negotiate the contract between employer and employee, the court said, is not absolute. Because obviously if a particular contract would harm other people, would create a danger to the public interest, then the state would be empowered to use its police power to override the contract. So the contract is not absolute. But the fact of the matter is, the court argued, in the majority of the court in the 5-4 decision argued that in this case, the court did not feel that working in a bakery was such a great threat to health and safety that it justified the exercise of the state of New York's police power in this case. Therefore, to pass the law constituted a violation of the Due Process Clause of the 14th Amendment. That was the court's case. And then we looked at two dissenting opinions. The first one by Justice Oliver Wendell Holmes, the second one by John Marshall Harlan, Justice Harlan. And as I mentioned, it was a 5-4 decision. So 4 of the justices, of the 9 justices, did not agree with the majority decision. Justice Holmes wrote his own dissent, his own dissenting opinion, in which he explained the basis for his dissent, and we looked at that. We looked at that yesterday, and one of the issues we looked at, because Justice Holmes' position was that in this particular case, the court was effectively imposing its economic theory on the nation against the will of the people. In this case, against the will of the people as reflected in legislation passed by their elected representatives in the state of New York. So basically, Justice Holmes' argument was that in this case, the court was imposing its own economic theory or bias, prejudice, on the people. Because, as he pointed out, a court decision becomes law. And that's effectively what the court is doing here, is making law. And it is basically establishing in law its own economic theory about the right to freedom of contract and the superiority of freedom of contract over everything else and the rest of it. So that was the basis of Holmes's particular position. You remember we read much of Holmes's dissent. It wasn't that long. And so if you go on the internet and if you Google the Lochner versus New York decision, or better yet, just Google dissenting opinions in the Lochner versus New York case, 1905, you will get copies of both Oliver Wendell Holmes' dissent and the dissent written by Justice Harlan, which is quite a bit longer than Justice Holmes' dissent. The point that I was making yesterday, and I want to reiterate it again because I really think it's important, and I think this is really what this Virtual Center for the Study of the United States Constitution is all about. We've got to get away, I believe, from the textbook approach to the study of history and the work of the founders, or the interpretation of the Constitution specifically. Most textbooks will tell us what the Lochner decision was. The Lochner decision was a Supreme Court decision in 1905 striking down a state law in the state of New York mandating a limit on the number of hours that bakery workers could work. That's mostly what and that is right. That is exactly what it is. But as I mentioned yesterday, and as I would like to reiterate again today, if you believe you really understand the Lochner decision without reading Oliver Wendell Holmes' dissent, then you're missing something. And the example I used yesterday was the number of people who believe that they understand the Dred Scott decision, yet they have never read the Lincoln-Douglas debates. And the Lincoln-Douglas debates revolved around the Dred Scott decision and the right of slavery to expand into the territories. And for those people who believe that they know Dred Scott and never read Lincoln's position papers against Douglas in the Illinois race for the United States Senate, are woefully deficient in their understanding. Because there's absolutely no question that you really can't understand and appreciate what the court did in Dred Scott unless you are aware of the positions and the arguments made by Abraham Lincoln in those debates. Likewise, you cannot understand the significance of the Lochner decision unless you are fully aware of what Justice Oliver Wendell Holmes said in his dissent. And what makes the Lochner decision particularly important? Why is it such an important Supreme Court decision? In this case, I believe that everything one would need to know about progressivism is laid out in one or the other of these position papers. The court's position in its 5-4, the court's ruling in Lochner, the majority opinion written by Justice Peckham, clearly lays out the priorities of America's past, putting ourselves in 1905 when this decision was rendered in April of 1905. The idea of the sanctity of contracts and the inviolability of individual freedom, and the whole idea of free enterprise, or as Justice Holmes said in his dissent, the idea that we are, in effect, legislating the economic theories of free enterprise. We are, in effect, legislating an economic theory into law. We are basically, taking the position and an economic theory and basically giving it the sanctity of law. And so, in effect, America's past, the entire theory, the traditional middle class approach about the way free enterprise must work, affected obviously by the writings of Darwin and Sumner and others, is very, very significant, because that's the economic theory that the court is imposing in Lochner. So what we see in Lochner, looking just at these two position papers, Oliver Wendell Holmes's dissent and the court's majority opinion, we are looking at the ingredients which give rise to what we call in American history progressivism. The idea that government, that the state, has a legitimate responsibility to care for and promote, as the preamble to the Constitution says, the general welfare, the public interest. And if you take the court's ruling in Lochner verbatim, directly, if you take that as truth, then that philosophy leaves no room for government management or regulation of the economy or the best interests of the welfare of the people it governs at all. That's the past from the perspective of 1905. The future is what we call progressivism, which is a redefined, much more active, much more visible, much more intrusive role in the nation's economy and in the welfare and day-to-day interests of its people, their health, their safety, their living conditions, their working conditions, the way they raise their families, all of it. Government is basically carving out for itself a significant role. And that's the position that Oliver Wendell Holmes is arguing in his dissent. So the decision in Lochner the case is very important, because it lays out the parameters of progressivism. And last week, you'll recall, we looked at Theodore Roosevelt's New Nationalism speech, and most people will say that the classic statement of progressive ideology is this New Nationalism speech of Theodore Roosevelt. Theodore Roosevelt is the classic progressive. And the point we made, and I think it's important to keep it in mind through all of this, the point we made is that Roosevelt's explanation of progressivism was not to advocate it as a radical position, but to advocate it as an intelligent conservative position. given the threat of radicalism that the nation faced in the late 19th and early 20th centuries, from immigrants, from Marxism, from labor unions, from agrarian organization and radicalism as reflected in the so-called Granger movement or the populist movement in the early 1890s, where the so-called majority faction that James Madison had warned so adamantly about in Federalist Number 10 was looking to take control of the political apparatus of this country out of the hands of those who had traditionally made the decisions and called the shots. This was potentially a very radical situation, and Roosevelt's position is, if we don't do something, we're going to lose it all. And so basically what Roosevelt's progressive ideology was about was a redefined role for government, where people could trust government to look out for their welfare as an alternative to taking control in their own hands of their own welfare, in a sense creating the equivalent of a vigilante state. It would end up to be lawless. It would end up to be chaotic. Everything that we know and value, people's property, people's security, people's stability, people's future, everything would be in jeopardy. So Roosevelt's argument or position is that in order to avoid that, we have got to take an intelligent middle road, and that middle road is progressivism. And the reason that, and I've had a number of people make the comment that this is something they had never thought about or heard before or whatever, and there's a reason for that. And I think the reason is significant. In this country, since the 20th century, the debate between liberals and conservatives, between liberals and conservatives, if you will, has focused principally around the appropriate role for government, whether in fact government does have a role, and if it does, how big or how intrusive that role can be or should be. When does government intrusion and government regulation become too much, become so much that it becomes entangling and cumbersome and creates more red tape and begins to be counterproductive? That's what conservatives will argue. But the alternative is, how much can we trust unregulated free enterprise? We just went through a recession in this country that began in 2007, 2008, that President Obama inherited when he was elected in November of 2008. And we know that unregulated free enterprise, unregulated banks and investment firms and securities and Wall Street and all the rest of it nearly put this nation and its economy under. And still we are having this debate. This issue is not resolved. Because the fact of the matter is, even though we know that a number of people did things that were most likely illegal, nobody went to jail. In fact, most of the stimulus money that the American taxpayer used to reinvigorate the economy went to the very people that created the problem and institutions that created the problems in the first place. So this issue is not settled by any stretch. But the fact of the matter is, the reason that this particular view that we're sharing here on the Virtual Center for the Study of the U.S. Constitution, the reason that this is considered by many people to be rather new and novel is because we have traditionally allowed conservatives to define progressivism. We have allowed conservatives to appropriate, to seize the middle in the ideological spectrum. And we have allowed them to define progressivism as radicalism, when in fact conservatism and progressivism both have a moderate strain. And moderate Republicans and moderate Democrats, or moderate liberals and moderate conservatives, can take up their place to the right or to the left of the center, of the midpoint. but neither one of them are extreme right-wingers or left-wingers. But we have allowed conservatives to define, we have allowed them to appropriate or to seize the middle ground, and then we have allowed them to define progressivism from where they sit in the middle as being radical. And most of us have bought that. And the reason is because we've listened to Ann Coulter and Sean Hannity and Rush Limbaugh and all these people for years repeat this mantra over and over and over again about liberals and conservatives. And we hear hosts in conversation and in television panel discussions. We hear them, very, very sarcastically and negatively talk about the government this, and the government wants that, and the government wants this, and the government will destroy that. And the implication is that we're dealing with some form of socialism here. And Theodore Roosevelt and FDR after him made the point that progressivism is not socialism. It is, in fact, a way to avoid socialism. And the fact of the matter is, thinking people, they believe, Roosevelt said over and over, thinking people would know that unless to accept it runs counter to their own agendas, their own self-interest. In other words, his position is that many people who insist on labeling progressivism as radicalism do so because they have their own agenda. They have something to gain by that. And we can see it with the Republican Party, as the Republican Party in the off-year elections in 2010 made significant gains in the Senate and the House. So the more successful these people are in defining themselves as moderates, as middle-of-the-roaders, who see progressives as radicals, if we allow them to do that, then by seizing the middle ground, they potentially seize control of the nation. And we've got to basically get some of this information and some of this perspective out there. People need to begin to see and understand exactly what's going on. So that's where we were yesterday in the Lochner decision. We looked at the court's majority opinion, and we looked at the dissenting opinion of Justice Oliver Wendell Holmes. And then we began to look at the second dissenting opinion in the Lochner case, which is written by Justice John Marshall Harlan. And what makes Harlan's dissent a little bit different than that of Holmes is that two of the other dissenting justices sign on to Harlan's. So you have four justices who vote against the decision, the majority decision in the Lochner case. Oliver Wendell Holmes, Justice Harlan, and two others. And the two others sign on to Harlan's dissenting opinion, not Holmes's. Holmes's dissenting opinion, I believe, there's a reason for that. I think, and I haven't done the research into the backgrounds of the other two justices to be able to say this. This is just I'm just speculating here. This is just kind of, maybe you could call it an educated guess. But my sense is that if you read Harlan's dissent and you read Holmes's dissent is would be a little bit scary to some people. To certain, I'm guessing that the justices probably were a little bit uncomfortable with Holmes's dissent because of the philosophy that is, that really runs all the way through it. Holmes and his idea of an economic theory being imposed on the nation is a little bit more than some of the dissenting justices are comfortable, would probably be comfortable with. And what makes Harlan's dissent more comfortable for them, I think, is that Harlan's dissent is much more academic than philosophical. And what I mean is Harlan's dissent makes the case for the right of the state of New York to pass this law. Harlan's dissent takes issue with the court's rejection of the idea that the health, security, safety, and welfare of those working in bakeries is serious enough, is threatened enough to justify the right of the court, of the state, to exercise its police power in this case. So that's a disagreement with the majority. For a couple of justices, that would just be a matter of disagreeing. But it would not be buying into a whole philosophical set of positions, which is what Holmes did. That's just my own guess. But anyway, we were looking at Justice Harlan's decision, and I mentioned at the opening of today's program, which actually was half an hour ago now. But I mentioned that Harlan's decision is one that should be worth read. I've got to share with you what I wrote at the bottom. I printed out a copy of Harlan's decision, and that's one of the reasons why I want the Virtual Center to have its own website, because I want to be able to post these documents online so you can look at them before we talk about them. And I think if you did that, if you had a chance to read these before we talked about them, then that would make you much more comfortable calling on the phone or reacting to them. If the first you've heard about these things is when I put them on the air, then it's kind of difficult without any warning or any preparation to react. I understand that. So I think a website is an intellectual necessity in what we're about here at the Virtual Center. But one of the things that we looked at in Harlan's dissent yesterday was the extent to which Harlan sets out to justify the state's right to exercise a police power. The state's rights, the state's government's right to look out for the health and welfare of the citizens that it governs. The court doesn't, in the majority opinion in Lochner, the court doesn't reject the police power, but it rejects the baking industry as enough of a threat to health and safety to warrant the use of the state's police power. And Harlan's dissent disagrees with that. And the other two justices sign on. In the copy of Harlan's dissent that I printed out, I wrote it. I read it again before we went on the air today, which is probably about the fourth time in the last 5 days that I've read this decision. And at the bottom of the third page of my copy is 5 pages long, but at the bottom of the third page, I wrote a note to myself, and I said, "What a fantastic legal brief! Use this in classes." This dissenting opinion written by Harlan is a classic example of how to write an argumentative essay, how to use fact, use information to argue a point of view. It's a fantastic document in that it is so well written and so well organized that it could literally serve as a primer to students who need to know how to write up primary information, primary sources, and how to make an intelligent, argumentative argument in support of a particular position. What Harlan does is go through the history of court decisions one after the other, and we quoted several of them, in order to make the case that the state indeed does have and needs to be able to exercise its police power, its right to police power. And it is using the court's own decisions as justification for this. In other words, this is an example of research of the court of Harlan going back into the history of the court in terms of its previous decisions and citing those cases where the court reinforced the necessity of the state police power. He's establishing that. What he's basically doing is laying the groundwork for a dissent that is going to take issue with the majority opinion in this case. It's a beautiful piece of writing, of argumentative writing. And as I mentioned yesterday, one of the things that I would like to get into probably tomorrow is this whole issue of argumentation and what it is and how we use it and why it's so important. And I think this is a classic example of that. And we read a number of quotes from previous cases, and I don't want to go back over them, but there are two or three that I want to I think we read a couple of these yesterday, and I just want to reiterate and begin with these because I think they are very significant. Harlan writes in Justifying the Police Power, he cites a case called Gunling versus Chicago. And he quotes the Supreme Court decision in that case, and this is the quote. Regulations respecting the pursuit of a lawful trade or business are of very frequent occurrence in the various cities of the country. And what such regulations shall be and to what particular trade, business, or occupation they shall apply are questions for the state to determine, and their determination comes within the proper exercise of the police power by the state. In other words, the state has a responsibility to regulate business. And Harlan goes on, and unless the regulations are so utterly unreasonable and extravagant in their nature and purpose that the property and personal rights of the citizen are unnecessarily and in a manner wholly arbitrary, interfered with or destroyed without due process of law, they do not extend beyond the power of the state to pass, and they form no object for federal interference. What he is doing is quoting a previous case, Gunling versus Chicago, in which the court laid out the justification for the police power and the need for the police power to regulate trade, industry, and business in a particular state, in a particular entity, and to point out that the state must be free to exercise that power unless to do so would become arbitrary and it would interfere or destroy the whole idea of due process of law. And then Harlan goes on and cites another case called Crowley versus Christensen. And he says this, as stated in Crowley versus Christensen, the possession and enjoyment of all rights are subject to such reasonable conditions as may be deemed by the governing authority of the country essential to the safety, health, peace, good order, and morals of the community. What he is doing is emphasizing government's right and responsibility to look out for the safety, health, peace, good order, and morals of the community. He is basically suggesting that that's what government does. That's what government is about. That's why man created it. To do that. And to deny the state that power by giving precedence to individual freedom to contract, Harlan is suggesting here, is nothing different than what Holmes said, which is imposing an economic theory, which is denying reality, denying history in favor of a particular economic theory. And then Harlan goes on and cites two more cases. I'm naming the cases, but the names are not that important. Nobody's ever going to remember them. In the case of St. Louis Iron Mountain Railway versus Paul, and in the case of Knoxville Iron Company versus Harbison, two previous cases, it was distinctly adjudged, says Harlan, that the right of contract was not absolute in respect to every matter, but may be subjected to the restraints demanded by the safety and welfare of the state, unquote. So in two previous cases, the court had ruled absolutely that the right of contract, the freedom of contract, was not absolute, and that it always had to take a back seat to the restraints demanded by the safety and welfare of the state. That, obviously, the public interest always trumps the private interest. And Harlan is not just saying this. Harlan is citing and quoting Supreme Court decisions in which previous Supreme Courts said this. That's pretty powerful support for an argument, I think. And then we have Justice Harlan reaching a conclusion about the police power. And I think this statement by Justice Harlan is absolutely unbelievable. He says, I take it to be firmly established that what is called the liberty of contract may, within certain limits, be subjected to regulations designed and calculated to promote the general welfare or to guard the public health, the public morals, or the public safety. And then he quotes a case of Jacobson versus Massachusetts, another Supreme Court case. Quote, the liberty secured by the Constitution of the United States to every person within its jurisdiction does not import, this court has said in Jacobson versus Massachusetts, does not import an absolute right in each person to be at all times and in all circumstances wholly freed from restraint. There are manifold restraints to which every person is necessarily subject for the common good. Let me read that quote again. That quote from Jacobson versus Massachusetts ought to be on every syllabus of every history and civics class in the United States. But as long as we allow the Limbaughs and the Hannitys and the Ann Coulters and the rest of them, the Michael Savages, to dictate what's on these curriculum, state curriculum guides or whatever, it won't be. This will never make it. That's why we're here. Let me repeat that quote from Jacobson versus Massachusetts. The liberty secured by the Constitution of the United States to every person within its jurisdiction does not import an absolute right in each person to be at all times and in all circumstances wholly freed from restraint. There are manifold restraints to which every person is necessarily subject for the common good. Without going back in previous programs, let me say, John Locke said that. But those who seek to use John Locke to promote their own agenda in today's world never talk about the common good. Locke talked about it. Locke talked about it all the time. But what those with an agenda choose to do is ignore that part of John Locke and focus instead on the responsibility of government to protect the private property of individuals. And then the next stage is to basically create or establish a series of court decisions which establish the principle that corporations are persons, so that when persons receive particular rights under the Constitution, so also do corporations. That's what we've been dealing with. That's what we need to basically get out there, it seems to me. I'm screaming here, and I'm sorry, but I can't. I find this stuff absolutely incredibly important. So I've written in the margin, this is pretty much a summary of where we are so far in Harlan's dissent. Granting, then, that there is a liberty of contract which cannot be violated even under the sanction of direct legislative enactment, but assuming, as according to settled law we may assume, that such liberty of contract is subject to such regulations as the state may reasonably prescribe for the common good and the well-being of society, what are the conditions under which the judiciary may declare such regulations to be in excess of legislative authority and void? In other words, what Harlan is doing is summarizing where we are, where he's come so far in his argument. And he said, granted there is a liberty of contract, granted there is this freedom of people to make contracts, and granted no legislature has a right to violate these freedoms unless The common good, as defined by the state, requires that the state interfere with them for the well-being of society. Then, let's assume that. Let's assume that there is a right of contract, and the right of contract cannot arbitrarily be interfered with by any legislature unless that legislature can demonstrate that the public good and the well-being of society demands it. Then Harlan says, now he's back to the court in this case. What then are the conditions under which the judiciary, the court, may declare such regulations to be in excess of legislative authority and void? In other words, where does the court come from saying the state of New York doesn't have the right to exercise the police power for the common good in this Lochner case? What are we talking about here? Harlan says. Upon this point, he says, there is no room for dispute, for the rule is universal that a legislative enactment, federal or state, is never to be disregarded or held invalid unless it be beyond question, plainly and palpably in excess of legislative power. In other words, in all situations, the legislature's responsibility to protect the security and well-being of the society as a whole, the common good, must always trump individual rights. And the only time that is not true is when the state is acting in a way which is an extreme abuse of its legitimate legislative power. Then Harlan says, in Jacobson versus Massachusetts, the court said, that the power of the courts to review legislative action in respect of a matter affecting the general welfare exists only when that which the legislature has done comes within the rule that if a statute purporting to have been enacted to protect the public health, the public morals, or the public safety has no real or substantial relation to those objects. In other words, what we agreed to, he says, in Jacobson, is that the court would look at the circumstances that the legislature saw when it chose to exercise its right. And then he goes back to a case we looked at before here at the Virtual Center in detail, the case John Marshall's decision in McCulloch versus Maryland, 1819. That's how this stuff works. And you may remember this. This is a play on the words, but we read this over and over again. If the end be legitimate. Remember, Marshall said that. This is what Harlan says. If the end which the legislature seeks to accomplish be one to which its power extends, and if the means employed to that end, although not the wisest or the best, are yet not plainly and palpably unauthorized by law, then the court cannot interfere. In other words, Harlan says, when the validity of a statute, a state law, is questioned, the burden of proof is upon those who assert it to be unconstitutional. And then he cites McCulloch versus Maryland for that decision, John Marshall. If the court chooses in its decision to deny the right of the state to pass a law in the public interest, then the burden of proof is on the court to demonstrate that that law is unconstitutional. And the majority in the Lochner decision did not. They just declared that the bakery industry is not enough of a threat to health and safety to warrant the use of the police power. There was no evidence, no proof, nothing. They just declared it. And Harlan is saying there's such a history of precedent in court decisions to prove, to demonstrate the responsibility of the state, of government, to protect the security and well-being of society, that whenever a court chooses to deny the state the right to exercise its police power, then the burden of proof is not on the state, it's not on the law, it's on the court. What a case Harlan has made. This dissent is incredible. What a beautiful, well-organized legal brief. If students ever want to be carrying around in their notebooks or in their backpacks an example of a well-argued argument, a well-structured, well-constructed position paper, using evidence, using quotations to back up a point of view, this is a classic. And yet nobody reads it. Nobody in any, even constitutional history classes. People will cite Harlan's dissent, but nobody reads it. They just point out that Harlan dissented, arguing that the police power should take precedence. But when you read Harlan's dissent, you begin to realize the basis on which he makes that argument. It's beautiful. It is an absolutely beautiful piece of argumentative writing. And then Harlan goes back to the well. He goes back to the issue at hand and says, basically, now we're at this point. So now the question is, Lochner. The state decided to pass a law saying that for people in the bakery industry, the bakery or confectionery industry, to work more than 60 hours a week or more than 10 hours in any one day is dangerous to the health and welfare of the people. And now Harlan goes back to the point he just made, and he said, be this as it may, the statute must be taken as expressing the belief of the people of New York that as a general rule, and in the case of the average man, labor in excess of 60 hours during a week in such establishments may endanger the health of those who thus labor. Whether or not this is wise legislation, it's not the province of the court to inquire. We don't have the right to decide whether this is an intelligent law. What we have to basically agree on is that the state has the right to pass it, because the state's responsibility is to protect the security and well-being of society, and that's what they're doing in this law. And then finally, and I'm not going to go into this, but the final piece of Harlan's argument is to cite a study conducted by a Professor Hurt on what is entitled Diseases of the Workers. This is a quote from a treatise on the dangers of the bakery industry. In other words, what Harlan is doing is he is supplying evidence to prove that the court's rejection of health and safety issues on the part of the workers is arbitrary and capricious, and the fact that there is evidence to the contrary for what the court majority did. And this is the quote from Professor Hurt's paper on the diseases of the workers. The labor of the bakers is among the hardest and most laborious imaginable, because it has to be performed under conditions injurious to the health of those engaged in it. It is hard, very hard work, not only because it requires a great deal of physical exertion in an overheated workshop and during unreasonably long hours, but more so because of the erratic demands of the public, compelling the baker to perform the greater part of his work at night, thus depriving him of an opportunity to enjoy the necessary rest and sleep, a fact which is highly injurious to his health. Then he cites another writer who says, the constant inhaling of flour dust causes inflammation of the lungs and of the bronchial tubes. The eyes also suffer through this dust, which is responsible for the many cases of running eyes among bakers. The long hours of toil to which all bakers are subjected produce rheumatism, cramps, and swollen legs. The intense heat in the workshops induces the workers to resort to cooling drinks, which together with the habit of exposing the greater part of their bodies to the change in the atmosphere, is another source of a number of diseases of various organs. Nearly all bakers are pale-faced and of more delicate health than the workers in other crafts, which is chiefly due to their hard work and their irregular and unnatural mode of living. The average age of a baker is below that of other workmen. They seldom live beyond their 50th year. And then finally, I apologize for the phone in the background. And then finally, the court says, when in 1720 the plague visited the city of Marseille, France, every baker in Marseille succumbed to the epidemic. So what Harlan has done now, and he has provided research, evidence to show that the bakery industry is indeed a serious enough threat to the health and well-being of the people who work in it to justify the state passing legislation to protect and regulate the workplace. That, effectively, is Harlan's dissent. What a beautiful piece of empirical writing. It is well organized. It cites all the sources. It takes on all the assumptions which the majority decision did not. You know, in a court of law, so to speak, or in a debate, in a traditional debate, there's absolutely no question that Harlan's dissent would win this hands down over the majority opinion in this case. But again, as Justice Holmes said, the majority in this case is mostly intent not on making law, but on imposing an economic theory on the nation and using that economic theory to deny the state the power to rule in the public interest. And this is the debate that we continue to have in today's world between liberals and conservatives about the proper role of government and whether government has a right to regulate, whether it should regulate, how much regulation, all of it. This period is critically important in understanding not only American history, what went before, but in understanding everything that has happened since. The court is articulating the philosophy of America's past. The minority, in this case, is articulating the justification for a totally new direction for the nation's future. And I would suggest to you, and part of it is because in the 20th centuries we experienced World War I, we experienced World War II, we experienced the Cold War, we experienced Korea, we experienced Vietnam, we experienced the Civil Rights Movement, and a number of other major socially upsetting events. The fact of the matter is the nation as a whole has never sat down and addressed this conversation. This is a conversation that the nation has chosen to not have. This is a conversation that conservatives don't want the nation to have. This is a position. This is a period when progressives were defining progressivism. What has happened in America since then is we have allowed conservatives to define progressives as radicals. And the vast majority of the American people who don't know, really don't know a whole lot more than what they hear. Will Rogers said, all I know is what I read in the papers. We have students that choose not to even read the papers. So the fact of the matter is, they are products and victims, I believe they are victims, of what they are told. Whoever has the loudest voice and screams the loudest wins the day. And it's having an impact on our education system and a number of other things in our society. So that is the Lochner versus New York case. And I hope that the time devoted to it is justified by the significance of the case itself. Basically, it seems to me that if you can wrap your arms around that case, what the court ruled and what the dissenters argued against what the court ruled, I think you get a fairly good idea as to what the basis of the debate is that exists at that time, but also that is going to continue to exist into the 20th century. And ultimately, what we are talking about here is a self-interest, I believe, a conservative corporate self-interest to use the historical past, to use the founders, and use the Constitution they crafted to articulate a position which would preserve the past in an age where change, the age of the Industrial Revolution, an age where the past interpretation of the Constitution is no longer valid. What we are talking about here is a transition, is reinterpreting the Constitution in such a way that it remains relevant. And that's, it seems to me, what progressivism has done. The Industrial Revolution changed the game. The Constitution was written primarily for an agricultural world. Most people were farmers. Jefferson wanted it to remain that way. Many people, John Marshall, Hamilton, and others, saw the future of free enterprise, but nobody could anticipate, it seems to me, the depth and breadth of what was going to be the Industrial Revolution. Nobody. And if you continue to interpret the Constitution the way it was written in a rural age, in a agricultural age for an industrial world, then it seemed to me you ended up having the kinds of problems that the nation faced with no mechanism, no way to address them. And under those circumstances, people had no option except to try to take the law into their own hands. Unions did, farmers did, whatever. We had all of these competing ideologies. The nation was in turmoil. At the late 19th century, the Industrial Revolution is one of the most telling, informative, important periods in American history. It's skipped over in our history book because a lot of people don't want to address the issues that are there. And very honestly, unfortunately, many of the teachers in our schools can't do it because in college they never covered it either. That's why we've got to get back to the sources. And we've got to really make an effort to understand. And that's what the virtual center's about. That's why we're here. So with that, let's take our break. We're a couple of minutes beyond the top of the hour. Let's take a 5-minute break. And when we come back, we're going to pursue this a little bit and move a little bit away from the Constitution and a little bit more into the whole idea of structuring argument, education, and critical thinking, and all the rest of it, which is what the Virtual Center is really all about. But first, we'll take a break. This is Bill O'Brien. We'll be right back. Thank you, Bob Kincaid. And if you are just joining us, welcome to today's edition of the Virtual Center for the Study of the U.S. Constitution. I am Bill O'Brien, and I welcome you to today's program, and I thank you for your to give up a portion of an important portion of your day and your valuable time to this program. I appreciate it. If you've been with us from the beginning 1 hour ago, thank you for staying with us. That says quite a bit as well. We spent our first hour looking principally at the John Marshall Harlan dissenting opinion in the Lochner case. Very important case, very important dissents, both Harlan's and Oliver Wendell Holmes' dissent, I believe. I think much of the debate that we continue to have in this country that surrounds the appointment of Supreme Court justices. Remember we went through this when When John Roberts was nominated as Chief Justice, we went through it. When Justice Alito was nominated to the court, we have a couple of justices on the court that are very aged and infirm. Ruth Bader Ginsburg being one, Justice Kennedy being another. And these things become such hot political issues, the nature of who sits on the court. And you can begin to see why. Because depending on where your philosophical druthers are, you'll either be in the majority here or in the minority on these very important political issues. And I think it's very important that the majority of the decisions that get the most attention, even today, are 5-4 decisions. Very, very important issues here. There's a lot to be learned. And yesterday, we talked a little bit about the whole issue of argumentation and the connection that it has to critical thinking. And I want to pursue this today and indeed tomorrow as well. I want to get into this whole idea of how to put together an argument and why an argumentative discourse is so very important in our educational system. Because obviously it, as much as anything else, is what's lacking in our public education system today, is the ability to do this and the willingness to do it. Teachers don't want to do it. Many of them don't know how to do it. Many of them feel that the very word argument is something they want to avoid, not embrace in their teaching. So by definition, we are depriving our young people of a very, very important skill. And one of the reasons I wanted to spend as much time as I did on Justice Harlan's dissent is because in that dissenting opinion, I see the value of the skill that I just mentioned revealed. That is one of the most beautifully constructed, organized, argumentative pieces of writing that you'll ever see. And I think it's very important, not only for what it says, but for how it says it. I think it's a very, very important thing. I think it ought to be in everybody's curriculum. Some of those quotations that Justice Harlan cites from the court, we have to believe. I mean, you have to believe. I'm just making an off the wall comment here, but I would suggest to you, Mitt Romney doesn't know, just using him as an example, that there are even statements out there like that. But the most important thing, the vast majority of the American population doesn't know it either. And that's what's scary, is that we are making decisions based on what other people tell us the truth is. Because many of us either can't find the time or don't have the incentive or don't have the skills necessary to pursue truth for themselves. And the degree to which that is true, speaks volumes about the weaknesses in our education system in our nation. And I mentioned that, before we took our break at the top of the hour, that I wanted to go into this a little bit, and I want to do that right now. There was an article that was published and shared with me from The Onion, and the publication date is the 14th of November 2009. But I'm a historian, so I don't think old stuff necessarily is bad stuff. In fact, the older the better. But I want to share with you the story of Kyle Mortensen, because I think the degree of the challenge that we all face is borne out in this particular piece. You read it, at points you laugh. I did anyway. At other points you cry. I did that too. So without comment at this point, I'm going to go as far as I can before I start to make comments, but I don't know how far that's going to be, because this is an absolute gem. But if you have any doubt as to what we are facing about education and about critical thinking and about skills and about our politics and everything else, then I ask you to think seriously about what I'm about to read. This comes from Escondido, California, and I'm reading it verbatim. Spurred by an administration that he believes to be guilty of numerous transgressions, self-described American patriot Kyle Mortensen, 47 years old, is a vehement defender of ideas he seems to think are enshrined in the U.S. Constitution and principles that brave men have fought and died for solely in his head. That's the criticism of the person who wrote this article. Kyle Mortensen would gladly give his life to protect what he says is the Constitution's very clear stance against birth control. Please point that out to me. Quote, this is Kyle Mortensen. Our very way of life is under siege, said Mortensen, whose understanding of the Constitution derives not from a close reading of the document, but from talk show pundits, books by television personalities, and the limitless expanse of his own colorful imagination. It's time for true Americans to stand up and protect the values that make us who we are. Unquote. According to Mortensen, an otherwise mild-mannered husband, father, and small business owner, the most serious threat to his fanciful version of the 222-year-old Constitution is the attempt by far-left traitors to strip it of its religious foundation. Quote, right there in the preamble, the authors make their priorities clear. One nation under God, said Mortensen, attributing to the Constitution a line from the Pledge of Allegiance, which itself did not include any reference to a deity until 1954. Mortensen said, well, there's a reason they put that right at the top, unquote. The preamble to the Constitution includes the statement, one nation under God, which clearly comes from the Pledge of Allegiance, and the one nation under God, the under God part was added in 1954. Quote, Mortensen again, men like Madison and Jefferson were moved by the ideals of Christianity and wanted the United States to reflect those values as a Christian nation, continued Mortensen, referring to the father of the Constitution, James Madison, considered by many historians to be an atheist, and Thomas Jefferson, an Enlightenment-era thinker who rejected the divinity of Christ and was in France at the time that the Constitution was written. The words on the page speak for themselves, Mortensen said. That's a quote. According to sources who have read the nation's charter, the U.S. Constitution and its 27 amendments, this is the author of the article writing, do not contain the word God or Christ. That's true. Nowhere in the document is God mentioned. Mortensen said his admiration for the loose assemblage of vague half-notions he calls the Constitution has only grown over time. He believes that each detail he has pulled from thin air, the author says, from prohibitions on sodomy and flag burning to mandatory crackdowns on immigrants, to the right of citizens not to have their hard-earned income confiscated in the form of taxes, has contributed to making it the best framework for governance since the Ten Commandments. Let's not forget, he said, that when the Constitution was ratified, it brought freedom to every single American, unquote. Of course, there are questions, you can obviously question that. Constitution legitimized slavery, as we know. Anyway, Mortensen's passion for safeguarding the elaborate fantasy world in which his conception of the Constitution resides is greatly respected by his like-minded friends and relatives, many of whom have been known to repeat his unfounded assertions verbatim when angered. Still, some friends and family members remain critical. His daughter, Dad's great, but listening to all that talk radio has put some weird ideas into his head, his daughter Samantha, a freshman at Reed College in Portland, Oregon, said. He believes the Constitution allows the government to torture people and ban gay marriage, yet he doesn't even know that it guarantees universal health care, unquote. That's a debate. Mortensen told, excuse me, Mortensen told reporters that he'll fight until the bitter end for what he roughly supposes the Constitution to be. He acknowledged, however, that it might already be too late to win the battle. The freedoms our founding fathers spilled their blood for are vanishing before our eyes, Mortensen said. In under a year, a fascist socialist regime has turned a proud democracy into a totalitarian state that will soon control every facet of American life. Don't just take my word for it, Mortensen added. Try reading a newspaper or watching the news sometime. Unquote. Notice there's so many places to comment here that it's probably not worth doing, but notice where he gets his information from. And notice even more where he doesn't get his information from, the document. Now, granted, Kyle Mortensen can be considered to be extreme. This is an extreme case. It's an article that you almost have trouble believing could be totally accurate, because you can't believe that there are people walking around like this, but yet we know there are. But the scary part, the part that makes you cry, is that so much of this, and this obviously is an effort on the part of the author to, this is what I thought of when I read this was, if you've read Jonathan Swift and Gulliver's Travels, or if you've read his essay on the solution for the overpopulation problem in Ireland, which I won't get into here, but it's about cannibalism. But the point is that it's tongue in cheek. It's very satirical. But it's scary because it's based on reality. There are so many people who get their news this way. We now live, everybody is talking more and more and more about social media. I heard this morning a discussion on ESPN radio about Twitter and all of the various forms of social media, and the host was making the point, and I think it was a good one, that it used to be 25 or 30 years ago, when the evening news was over, when the 6 o'clock news ended at 7, the news ended, and it didn't come back again until the next night at 6 during the evening news. But now the news is 24 hours, and because of Twitter and some of these other communication the revolution that we have in communication, news builds up steam overnight. What can be a minor story when we go to bed is a major news item by the time we wake up in the morning. And the reason is people are being given information, and they are being told this is true, that's true, this is true, that's true. And people are kind of forced to make a choice, because one of the things that we are being told as a society is that being a moderate is no longer acceptable. You're either with us or against us. You either are for this or against this. You're for abortion, you're against abortion. You're for gay marriage, you're against gay marriage. You're for war, you're against war. You're for pollution, you're against the pollution, or whatever. Well, the point I'm trying to make is it becomes very difficult to justify not making a decision in some of these cases. And it is so overwhelming that people do not have the time And unfortunately, they don't have the inclination to go dig out some of these things for themselves. And so the fact of the matter, I'm not saying anything that many of you don't know. I mean, you can read the research on this, and it'll confirm it. The reasons that people give for why they vote the way they vote. I can remember reading commentaries. I remember when Jimmy Carter was elected in 1976, reading a comment from somebody who voted against him, who made the comment and said, when Jimmy Carter smiles, anybody that has a set of teeth like that can't be telling the truth. Anybody that smiles that big can't be telling the truth. And basically, what we end up responding to is whether we believe that an apology is sincere. How sincere? Is it sincere enough? I'm thinking of the Ryan Braun situation in baseball and all the rest of it. And we are left to make our decisions on things that really aren't substantive enough to become the basis for decision-making. We are voting for or against particular people on how they look, what they wear, where they come from, where they drive, who they married, everything, what they read, everything. And it's very important. And if you don't believe this is important, take a moment sometime and just start to pick a major corporation. I don't care which one it is. But begin to look at some of the sub-companies that are owned by corporations. Are you ever amazed to know, when you find out that such and such a company is owned by this other company, you didn't even know that they were connected? For example, one of the things that got me, and it's a local issue here for me, but one of the issues that I came across within the last week, which surprised me, is I had no idea that Applebee's, the restaurant chain Applebee's, is owned by IHOP. Is there a reason that I should know that? Is there a reason for IHOP not to basically brag about that? And I guess what I'm saying is, what kinds of information do we have or not have that become the basis for making the kinds of decisions that we have to make? Before we went on the air today, I was talking to my wife on the phone. She asked what I was going to do the program on today, and I mentioned Justice Harlan and his dissent in the Lochner case, but I also mentioned something else, and she said, "What?" And I said, "I think before we get off the air today, I'm probably going to be a little bit, at least, into epistemology." And she said, "Into what?" And I said, "Epistemology." And she said, "What's that?" And I said, "The study of knowledge." And she said, "How many people listening do you think even know what epistemology is?" And I said, "Well, maybe it's time we find out." And the reason is, what led me to it was this piece from The Onion on Kyle Mortensen. This beautiful piece of writing on where he got his information from, and the fact that he is clearly so facile, so easy in moving information around. How many times have you heard people that confuse the Declaration of Independence with the Constitution of the United States? It happens all the time. It happens by our political leaders. I've heard political people in speeches make that mistake. And the point is that people are playing fast and loose with the past, with the founders, with the principles of the founders, with the Constitution, with the interpretations of the Constitution. And when called, when a mistake that they made is pointed out to them, frequently the response that you'll get is, "Well, the details are really unimportant. It's the point itself that matters." And what they're basically saying is it doesn't matter whether what you say is accurate or not accurate. It's what you believe that matters. What I'm about is to get you to believe what I think you should believe. That's what matters. And whatever I have to do it is okay. So the ends justify the means. And it is against this that our education system is working. We have to rely on our education system in order to equip people to be able to combat this. And unfortunately, our education system, at least up to now, is not up to that. It's not up to that challenge at all. And it's not the whole reason. Part of the reason is that our teachers aren't up to it. And part of the reason that they're not up to it is because our college instructors aren't up to it, in many cases. It is very, 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 very important that we begin to think seriously about what we want and what we mean by education in this country. What we want our young people to be, what we want our young people to know or not know. I'm not going to go back into it again. I've quoted it many times before. But the statement when the United States Senate passed legislation in 1816 imposing a tax on foreign books in order to keep them out of the country, in order to shield our young people from dangerous foreign ideas. Think about that. Think about what we require authors to go through to get a book published. Think about what editorial boards do to copy before they'll approve a textbook or a chapter or whatever. No wonder textbooks are dull. Everything that says anything is removed, because if you say anything, you're going to offend somebody. And if your number one priority is never offending anybody, then the only way to do that is not to say anything. And to put a whole book of several hundred pages together between covers, the number one priority of which is not to say anything, and then give it to a student and demand that the student master it, is incredible, if you think about it. Absolutely incredible. So let's take, and we've got about a little bit better than, not quite a half an hour left in our program, and I don't want to get into this in too much detail because I don't want to lose everybody. And I could lose you very quickly because this is a little bit out of my league too. Epistemology is not one of my strengths, but the whole idea of epistemology is the idea of the nature of knowledge, what we know, what we don't know, how we know it, why we know it, how do we know that something's true or not true, those kinds of questions. Basically, there are two approaches to this, and there are two division that we usually define as rationalism and empiricism. I mean, I'm not just throwing out terms here. But these are terms that all of us have come across at some point in our lives, although we probably haven't focused that much on them. The idea of rationalism and empiricism. The difference between the two is significant. Rationalism is the idea that we can acquire knowledge, or we can learn as a result of reason. In other words, if we appropriately apply our intellectual skills to a particular issue, reason will lead us to knowledge. Empiricism, on the other hand, is based on the idea that real knowledge, true knowledge, is based on experience. And that means you can't know it until you've experienced it. So the question is the old debate between nature and nurture. How much of knowledge is already within us? Or as John Locke talked about in his essay on human understanding, how much of what we know is the result of our environment, of experience? John Locke came up with the idea of tabula rasa. We talked about this before, that man is born as a blank slate. In other words, when man is born, he knows nothing. And that everything man knows, he learns through experience, through his environment, through what he sees and what he hears and what he smells and what he tastes and what he touches. He's a product of his environment. And that becomes the driving philosophy of the 17th and 18th century, which really kind of is part of the foundation of what we call the Enlightenment era. And this is the era, this is the way of looking at the world that produced Jefferson and Madison and all the rest of them. The founders were products of this idea of environmentalism, of this idea that man learns through his experience, through what he's exposed to, through his environment. And the idea based, if you take that to the next step, it's pretty logical that if you believe that everything man knows is based on what he learns from the environment around him, then the next logical point there is that if you can control that environment, you can literally shape the person you want to shape. You can create whatever you want by controlling the environment, which is the basis of everything that people know. It is not an accident, for example, that when we use the word nursery, we talk about daycare, a place that takes care of toddlers and little children, babies. We call it a nursery. But also in agriculture, we call a nursery a place where we basically grow and produce plants. And the connection here is not that different. Because the assumption is in raising plants and growing flowers, for example, that if you provide the proper nutrients, if you regulate the sunlight, if you provide enough moisture, enough water, and nutrients, you will grow a healthy plant. Because ultimately the environment within which that plant is asked to survive is an environment that you control. Well, many people take that and directly attribute it to people as well. John Locke did. And his assumption is what we are is based on the environment we grow up in. And the debate continues from then until now. Not just from then, but from long before then. The debate continues about how much of this is true, how much of it is nature, how much of it is nurture. How much of what we are is what we've learned, how much of what we are is innate, is what we're born with, is genetic. And the debate still goes on. I would suggest to you that our entire education system is based on the idea that the right environment will produce the product that you are looking for. That, in a sense, our classrooms are nurseries in the traditional sense. So the debate, the issue, it seems to me, the whole idea of knowledge and what is good knowledge. So again, empiricism is knowledge obtained through experience. Rationalism is knowledge acquired through the use of reason. And basically, the reason that epistemology, the word itself is a tongue twister, but the reason that it's important because it's fundamental to how we think. Sound thinking and reasoning depends on what we recognize and what we accept is truth as knowledge, and what we don't. And the best way, not necessarily the best way, but a best way is to look at the difference between atheists and theists, those who believe in God and those who don't, in terms of what they believe to be true and what they don't. And you begin to get a sense as to what's going on here in terms of knowledge. If you've had a debate with, for example, if you've had a debate with a fundamentalist Christian, I had one at the door of the house here a few weeks ago. I was telling my wife about it. It was kind of interesting because that was a particular day when I felt like playing a little bit, and I did. But for example, atheists, the whole idea of atheists raised the question: is it even reasonable to believe that there is a God? Is it reasonable to believe in miracles? Is it reasonable to accept revelation and scriptures as authoritative, as the source of truth? What basically atheists and theists are disagreeing about are epistemological principles. How do you argue with somebody who said the reason I know that's true is because the Bible says so? How do you do that? So the fact of the matter is that the theist approach to knowledge is based on faith and revelation and intuition and tradition and custom and the past. In other words, all these things go into the determination as to what's true and what's not true. What happened before, what's been accepted as tradition, what's considered to be customary, the whole idea of revelation, faith, intuition, your gut feeling. Remember the quote that we looked at several weeks ago from Thomas Jefferson, who said if you raise the same question with the professor and the plowman will oftentimes be more correct in his response than will the professor. Because the plowman's reaction is going to be from the gut. It's going to be honest. It's going to be from his heart, not his head. And what that means is the professor, through the educational system, has learned a lot of games, intellectual and academic games to play, where they can twist things around and twist the truth and all the rest of it. But the plowman is going to give you an honest sense of what he believes, or what he believes to be true, or what his intuition tells him, or what his gut tells him, or whatever. And Jefferson raised the question and said, oftentimes you're much better relying on that definition of truth than you are the academic or the intellectual definition of truth. If you go on the internet and you look up epistemology, you'll get a series of questions as to the kinds of questions that really are epistemological questions. Questions like, what can we know for sure? How can we know it? I mean, if you ever thought about it, in some of the philosophy classes that discuss knowledge, they're deadly. I mean, this puts people to sleep. I'm listening very hard to see if I'm detecting any snoring out there. But the fact of the matter is, the point is well worth taking. How do we know what we know? How do we know that what we know is worth knowing? How do we know, why do we know some things and not other things? That's an epistemological question. How do we acquire knowledge? In the laboratory? Through research and experimentation? If you perform an experiment and get a particular result, and you can't perform the same experiment and get the same result a second time and a third time, does that mean that what you thought you knew really isn't true? Is knowledge even possible? Is it even possible to know for sure what we think we know for sure? Can it be certain? Can we be certain? How do we separate, or how can we distinguish between what's true and what's false? Because people we trust tell us? Or is there a way, is there some process that we can go through that enables us to separate truth from falsehood? Why do we believe certain things or claims and not other things? On what basis? Is it based totally on trust, on faith? Do we believe what this person tells us because he or she has a collar on? Do we believe what this particular book says because there's a cross or a crucifix on it? I can remember in the Catholic Church, the Church used to tell us that the way you determine truth in a book was to look at the front and see if it had the imprimatur on it. If the book had imprimatur in the first couple of pages on the title page, that meant that the Church had ruled that what is in that book is okay for Catholics to read and believe. But if the imprimatur wasn't there, then you can't. I can remember being told that when I was a kid. These are all epistemological questions, and they are all important in the debates. And the point I'm trying to make is, if we really don't understand what all of this is about, then people tend to talk right by each other. They don't communicate, they don't dialogue, they don't interact, they don't learn from each other, because they're coming from two different perspectives and they're talking right past each other. They are not communicating. And the fact of the matter is, there's no way that one is going to persuade the other. So it seems to me part of what we have to do, part of what we have to know, is how to separate truth from falsehood, how to know what to believe and what not to believe. And I would suggest to you that more often than not in our society today, too many of us take as gospel what we hear or what we're told because of the person who's telling it to us. This person, if you look into this person's eyes, it's clear that you can trust them. I can remember somebody saying one time, look into the eyes. If you can see right into the soul, then you know that you're talking about somebody that you can take what they say to the bank. You can trust what they say. But if you're talking with somebody and they won't look you in the eye and they'll never look at you, you can't afford to trust or believe what they say. Think, my whole point here, and we don't have that much time left. We can hopefully continue this a little bit tomorrow and get into a little bit of substance here about argumentation and primary sources and critical thinking and all the rest of it. But the reason it's important is I want to go back to the Mortensen piece we opened this hour with. If you don't believe me, read a newspaper or turn on your television. Listen to what people are telling you. And what this person is saying is, I trust what I hear or what people tell me. And I'm so sure that I know if I go to if I get all my news from Fox or I get all my news from MSNBC, I'm getting the truth. Think about that. Think about what that says. Think about the extent. I'm thinking of the comment and email that I referred to. I quoted Betsy yesterday from Texas, who emailed me over the weekend and made this comment and said, that in her experience in middle school, she experiences students who really believe that opinion is fact. Can we criticize students for that when so many adults believe that opinion is fact because it's an opinion that they agree with? Oliver Wendell Holmes, in his dissent in the Lochner case, made the point that in order to vote for the decision, in order to vote with the majority of the court in striking down the New York state law regulating the hours of work in bakeries, you have, in order to be part of the majority in that decision, you must subscribe to the economic theory that drove the decision. And his point is, in a court of law, we are not into the imposition of economic theory. We don't have the right. We don't have the right to tell people what's true or what to believe or what's false. We don't have the right to do that. That's why people have minds. That's why people have reason. John Locke said that. God gave us a mind to use. And can you believe in a republic, in a political system where government is to be responsible to the people it represents or it governs? There are so many people that accept the fact that you don't have to waste your time learning or thinking. Just go to such and such a channel, and the people who believe the right things will tell you what to believe. And that's what we're dealing with in today's world. I think that's what we're dealing with here at the Virtual Center. The reason that the Mortensen piece is so powerful, I believe, is because it's an extreme example of the idea that it doesn't matter where you get your facts as long as they support what you believe, what's right, what's true. And there's no responsibility, no sense of responsibility to go back and check out these facts. And of course, the fact of the matter is many people wouldn't have the skills to do that anyway. And the question I'm asking is, to what extent is the way we approach education a process of making sure that the people that go through our education system come out the other end believing the right things. And if that's what our education system is about, then no wonder we have people who can't get jobs and who can't compete in a much more competitive global environment and global marketplace. I can't tell you the number of times that I have had students tell me face to face, looking right in my eyes, and say, it must be something wrong with me because I read a particular point of view and it makes perfect sense to me. And then I pick up somebody who says something directly opposite and that makes perfect sense to me. Which is right? And the one factor or consideration that's not even on the table there is that you are the one that's going to determine which of those is right and which of those is wrong. But in order to do that, you can't afford to just believe. You have to think. You have to reason. You have to apply logic. You have to read and think carefully enough that you are able to spot assumptions, intent, that you are able to spot faulty assumptions, where you can say something like, in order to buy this argument, I have to believe such and such. And I'm not sure I believe that such and such. But what I realize is, if I don't believe that such and such, then I can't buy this argument. It doesn't make sense. The only way that I can totally buy this package is if I buy these assumptions, and I'm not willing to buy them. And then you go to the next one and apply the same critical skills. What is this person saying? What does this person believe? What do you have to believe in order to accept what he's saying or she's saying? What do you have to believe? And that's the way you begin to ground yourself and gain some stability in understanding the nature of evidence and the basis of knowledge. That's what education's about. And that's, it seems to me, what we're going to have to spend more time about. And in history, for example, I believe, at this point in my life, I have to believe that it's absolutely essential we go back to the sources. And we stop relying on what people tell us people meant by what they said, and we begin to read and think for ourselves so we can react and know exactly what they said. And when you do that, you begin to realize how much of what we thought we knew for sure is really the product of somebody's political priorities or political prejudice or whatever. How much of what we thought we believed to be true is really trust that we had in somebody to tell us the truth, but they really were telling us what they wanted us to believe. I think that's where we need to go. We are at 58 minutes after the hour. Our day is done. Yesterday, I ran right into Bob Kincaid's program, and I don't want to do that. I want to give Bob a couple of minutes to fire up. So let me pick up today and end today by thanking you for staying with us. Thank you for tuning in to the Head On Radio Network and to the Virtual Center for the Study of the Constitution. I invite you to come back tomorrow. We'll be here again. Tomorrow will be regular time, 4 to 6 p.m. This is Bill O'Brien. Thank you so much for listening. Please be safe. We want to make sure you're back with us. Thank you and goodbye.